I explained that very clearly. I think I explained it actually to both sides during the couple of final settlement conferences that we had. So I don't know why it's being raised. They have elected throughout these number of years to have the case remain here. So at this point, I'm not removing it. What do we have? Everybody from Pittsfield PD here? Does Pittsfield have anybody on the road? I mean, I'm just thinking. The fire department's here. Yeah, everybody's here. You guys take care. Thank you, Mr. Schiller.
Thank you.
Mr. Schiller, can you approach on a separate matter? Or that's called the case of Finney versus Sedoni. The first thing, you guys are gonna have to switch sides.
Buckle up, guys. Today we are going to witness a courtroom moment where patience, procedure, and authority collide. The judge opens by making it clear this case is staying right where it is, despite years of opportunity to raise concerns. The tone is firm, almost impatient, as the court resets the room, calls the case, and signals that excuses and last-minute maneuvering will not set the agenda today. This is the calm before a procedural storm.
State your appearances, please.
Good morning, Your Honor. This is Megan Dogwalla on behalf of the plaintiff, P84205. Mayor, can you state your name?
My name is Maria Finn.
Peterson.
All right. It's a date set some time ago for a non-jury trial. Are the parties ready to proceed?
Your Honor, may I approach the bench and go off the record briefly before I begin? I have a procedural issue.
A procedural issue?
Yes, I can stay on the record.
That's fine.
Oh. May
What? No, well, then I've got to have them up here.
Sure.
I guess, what is it?
Okay, so there is a counterclaim, which is what this is a separate full trial. There was already an order of eviction entered. I'm intending to move for summary disposition under C8 and C10. I need the opportunity to brief that issue.
Well, why am I here on the date of trial with that?
Right. So the last motion that was filed, it was back in July. I appreciate that this is a long time coming. So please, Your Honor, I'm not appreciating that for its time. However, I'm recently retained, and there's about 1,000 pages worth of evidence. This has gone to mediation. There's conflicts in the facts, even in what was submitted during mediation, and there's significant evidence indicating issues of fraud upon the court and other issues regarding insurance fraud by the defendants. And it is my professional opinion that it does substantiate claims under MCR 2.116 C8 and C10.
Well, the motion should have been brought before today.
Okay.
I mean, I don't know what particular issues you're talking about in terms of somebody committing fraud upon the court. And I'm just going to say this, if they were going to say this about the other side, if you're going to make that accusation, counsel, you better bring it. And it better be that, because if it's not, then I'm going to be exceedingly angry, because I don't like people. I do not like people accusing others of things like that without substantial proof.
Absolutely. It is a substantial issue in this case. My client's rights have been significantly violated. It's
by whom?
By former tenants. This started out as a non-payment of rent case. As I mentioned, there was an eviction action, there was an order of eviction. As you're aware, we're here on the bench trial for the counterclaim. I don't take a claim of fraud upon the court lightly. There is significant evidence to present that. And I don't want to disparage my client's rights by not attempting to have this dismissed under C8 and C10.
Well, I get it, but there was an attorney in this before.
He's exceedingly difficult to get a hold of. That was part of why I asked to approach the bench, but
He's
understand
been
there's
held
something.
up. He was in court here Monday, so I don't know
Okay.
why he's not that difficult to get a hold of.
Okay.
At this
Um,
point, the attorney attempts to slow everything down, raising a procedural issue moments before trial. As an observer, it's clear the judge is unimpressed. Claims of newly discovered evidence and allegations of fraud are met with sharp warnings. The court stresses that such accusations require serious proof and should not surface on the trial date. When an adjournment is requested, the judge draws a hard line, making it clear the case will move forward today, one way or another.
Coming in on the date of trial, asking for an adjournment of these proceedings is not going to happen.
Okay.
So you guys either can try to resolve this thing, or we're going to try it.
Okay. Fair enough. Then I would request a brief recess to please speak to the defense.
Okay, see if you guys can work it out. Court's going to stand in recess.
14A District Court back in session, the Honorable Jake Sederson.
You may be seated. Back on the record, court does call the case Finney versus Sedona. All the parties are present, and how did the conversation go?
It wasn't entirely productive, Your Honor. So we have back from 2021 a consent order for conditional dismissal. There was an eviction order entered after that time against the defendants. As it relates to today's full bench trial, it is based on a counterclaim that was filed on February 12th, 2021. However, again, it's my position that the counterclaim needs to be dismissed. There's not actual cognizable claims under the counterclaim, so that it would be right for dismissal under MCR 2.116C.
Why are they not cognizable claims?
The claims are not cognizable as defendants are now pro per in this case. This was filed by their previous counsel. There is not a cognizable claim in regard to the condition of the property as against my client for relief.
Why is that not cognizable?
Can you repeat the question?
Why is that not cognizable claim?
It's not a cognizable claim, Your Honor, because there is a conditional dismissal entered as it relates to the original complaint where the defendants were being sued for the non-payment of rent, where the counterclaim asserts a generalized claim without any sort of reference to a breach of habitability or constructive eviction. The way that it's written in this counterclaim, it's more pertinent to the affirmative defense that's given the case history here and the fact that there was an eviction order entered. At this time, this can't be a cognizable claim before the court.
That doesn't even make any sense. If somebody says I paid $1,000 or rent was $1,000 a month, I didn't pay the $1,000, and actually I was living in conditions that I think the landlord may owe me money because I paid them or something happened to the unit. The very fact that there was an agreement to vacate the premises doesn't negate their claim for money. As it wouldn't the landlord, if the landlord had a claim for money.
Absolutely, Your Honor. My point is more towards, to back up
When
slightly.
court resumes, the focus shifts to the counterclaim itself. The attorney argues it lacks legally recognizable grounds, repeatedly labeling it improper and outdated. The judge pushes back, dissecting the argument with practical examples and pointing out that eviction does not erase potential financial claims. As a third-party observer, the tension rises as the judge demands clarity and legal authority, signaling frustration with vague explanations and unsupported assertions.
Slightly. This has been in court for a long time. There's a lot on the record, especially for something that started out as a non-payment of rent case. The defendants are the relatives of the plaintiff.
I'm aware. I'm aware of a whole lot in this case.
There are facts in the counterclaim that are very generalized. There's not a factual section or actual claims after that. It's very generalized, but it does assert that there's a dispute as to mortgage payments. There's a dispute as to ownership interest. So this is out of the realm of a landlord-tenant non-payment of rent case. And it's not a cognizable claim under the statutory law for those damages. Secondly,
You keep saying that. Give me some case law that says that.
Okay. May I move on to a second point briefly and then return to that, Your Honor?
Go ahead.
Okay. Secondly, after the generalized facts in the complaint, then the defendants move on to enter under a claim of statutory conversion, common law conversion, excuse me. Well, okay.
Regarding the insurance fund.
It's both. In paragraph 28, it's combined into common law conversion and conversion under MCL 600.2919A. Now, again, of course, Your Honor, we're considering what the language actually is in the counter complaint, but it's to my point that these claims are entirely convoluted. But they're asking for, as you would be entitled to under statutory conversion, 3 times the amount of actual damages plus costs and reasonable attorney's fees. If there's no summary proceedings to be had in terms of the possession of the property, and what's at issue here are ownership interests and statutory conversion claim that exceeds $25,000, it's in the beginning, as I was arguing to you, that this would be appropriate for dismissal under MCR 2.116C7. However, even if
jurisdictionally or under 7? Why under 7?
Right. This is what I'm stating, Your Honor. In the beginning, maybe it wasn't helpful to move on to a different issue, but in the beginning, it's that there aren't cognizable claims that apply any longer, given the procedural history. Not only that, but also just the way that it's been written out here in terms of the habitability. I did need a brief moment to consult my information, but in terms of the habitability, the actual counts that would indicate that the legal requirements have been met are not enumerated. And then secondly, it would be appropriate under MCR 4.002 not necessarily to dismiss the action, but if it's related to property ownership, which is quiet title, and if it's related to conversion for a claim of over $25,000, it's not the court's obligation to dismiss it, but it would be more proper that this be transferred to the circuit court.
And have you asked for removal?
I would request a removal, Your Honor.
I'm not removing this case.
Okay.
I think it was, and you coming late to the game, I think I explained to the Sidonis I don't have jurisdiction over the title.
Okay.
I also explained to them that my jurisdictional limit was $25,000. I explained that very clearly. I think I explained it actually to both sides during the couple of final settlement
The
conferences.
final stretch becomes a decisive shutdown. Jurisdiction, removal, and dismissal arguments are revisited, but the judge firmly rejects them, reminding both sides that these issues were explained long ago. Describing the objections as meaningless noise, the court refuses further delay and orders the trial to proceed. Authority is fully asserted, and the message is unmistakable. Today is trial day. Like the video, subscribe to the channel, and we'll see you in the next video.
Conferences that we had. So I don't know why it's being raised.